I'd like to go over specifically those voting rights that were protected. The 24th Amendment, of course, eliminated a poll tax. Remember, your grandfather clause was considered unconstitutional in Gwynn versus the U.S. in as early as the 1900s. Um, Smith versus Allwright got rid of the all-white primaries, but we still had poll taxes in place, and they were eliminated with the 24th Amendment. The Voting Rights Act of 1965 was also passed. That ended a literacy test. It gave the Department of Justice, and at this point, the Department of Justice had a particular office called the Department, or excuse me, the Civil Rights Bureau. Gosh. And the Civil Rights Bureau within the Department of Justice had the authority to approve any voter qualification or redistricting changes that 9 states in the South would pass. So if you look at these states right here and certain districts, that meant anytime any of these places that are in the dark blue wanted to change a voting law, a qualification, or redistrict, they had to get approval, or what is called pre-clearance. So they had to get their laws pre-cleared through the Department of Justice Civil Rights Bureau. This was actually Section 4 and Section 5 of the Voting Rights Act. Now the results were that you saw a significant increase in black voter turnout and participation. And in turn, you saw a significant increase in the number of black representatives and senators. The Voting Rights Act also was amended and revisited in 1975, where we decided that there had to be election material in multiple languages, and that's really going to apply to Native American populations. And when we get to Native American populations, we'll talk about that as well. Now, this part, this pre-clearance, where the Department of Justice has to view what these states do before they can implement a law regarding voting, has since been repealed in the court case of Shelby County versus Eric Holder, our Attorney General. So now southern states can kind of do what they want without having to get approval from the Department of Justice. In return, you have seen some states pass some discriminatory laws. Okay. There is segregation still allowed. There's a guy who, in the heart of Atlanta, hotel. There you go. Now, what we have tried to do in this country is to get rid of de jure segregation, or segregation by law. But segregation by law still exists in some cases. And the only time it can exist, segregation, is to protect the people. So if there is a discriminatory law on the books and it gets challenged in court, the Supreme Court has a couple of tests that they use to determine if it is harmful segregation or if it's segregation meant to protect. Reasonable classification. This is when the court determines it is okay to distinguish between two different groups of people and treat one group differently to either protect one group or the other. So it's reasonable to classify different groups of people and treat one group differently. That would be like smokers versus non-smokers. It's okay to treat smokers differently and deny them certain rights, like being able to smoke in a restaurant, in order to protect the non-smokers' rights and health. Rational basis. The rational basis test says that there are justified reasons to discriminate against a group. Now, that would be like under 16-year-old can't drive, under 18-year-old you can't, or 18 years old you can't buy cigarettes, under 21 years old you can't drink. And there's a rational reason for this decision, because you can't necessarily make reasonable decisions. Your brains aren't totally developed until you're 25 years old, so you might not make the best decisions when drinking or when smoking. Oh lordy, strict scrutiny test. Laws state um, any laws that states make that are or seem prejudiced or discriminatory are suspect or suspect classification, and the legislators must prove that there is a true interest in serving the public good. So any discriminatory laws that are suspect classification go through a strict scrutiny test where again they'll be, is this a reasonable classification? Is there a rational basis for this discrimination? Okay, affirmative action. I want to clarify something. Affirmative action is not quotas. Okay? Affirmative action is a policy that goes beyond preventing discrimination, so like the Civil Rights Act, ban discrimination. So, but affirmative action is a policy that goes beyond preventing discrimination to provide members of a minority group who have historically faced discrimination a leg up by allowing that group to get compensatory treatment or consideration. So it's a fancy way of saying if your race, gender, ethnicity has traditionally been discriminated against, there are policies in place that allow you to get a little extra consideration. That is not a quota. Quotas are policies requiring an institution or an employer to have a set number of positions filled by minorities. So a quota would be like, I have 100 positions for this law school and 50 of them must be filled by a minority group. That is not the case. Affirmative action and quotas are different. Now affirmative action is in place to fight de facto segregation. De facto segregation is segregation by fact. And the affirmative action tries to alter the patterns of discrimination. And this is where the debate lies. Is it the responsibility of the government to burden, quote unquote, burden employers or colleges with seeking qualified minority candidates? If a qualified minority candidate doesn't apply, how far do colleges and employers have to go to seek them out? Is there, if white people don't apply to a job, or excuse me, if minorities don't apply to a job and only white people do, is that the employer's fault, and can the government hold an employer accountable? But on the same token, affirmative action is in place because whether people realize they're doing it or not, a white boss might just be naturally inclined to hire a white candidate. Even if you had a black candidate that was equally qualified, you might just feel more comfortable with the person that you are, the kind of person you're most surrounded with. In the court case 1978, California versus Bach, I've always said it Baki. I don't really know. I guess I should find out how it's said for real. A white medical student, this guy right here, he was a candidate for medical school. He sued the University of California because he was not admitted to the school when a lower scoring minority was admitted. And the Supreme Court ruled that race can be a consideration for admissions, but like in this case, University of California couldn't use it as the sole determining factor. So if you have two equally qualified candidates, you have a black candidate, you have a white candidate, you have to choose the black candidate before the white candidate, or you should choose the black candidate before the white candidate, but it can't be the only factor. Okay, Gratz versus Bollinger and Grutter versus Bollinger. We talked about these cases earlier. The court struck down the use of bonus points for race for undergraduate admissions to the University of Virginia, or University of Michigan, sorry. But in Grutter versus Bollinger, the Supreme Court allowed the use of race as a general factor in law school admissions. So you couldn't use race for undergrad, but you could use it for graduate positions like the law school of University of Michigan, because law is something that wasn't traditionally um, traditionally pushed in the African American community. 1991 Civil Rights and Quotas. 1991 Civil Rights Act, right? The Civil Rights Act. All employers are supposed to prove that their hiring processes and hiring practices were not discriminatory, and that meant everything from saving old applications and making sure that um, making sure that you weren't just filing away minorities' applications, but you were considering them as well. Um, Now, again, we called this the quota bill, and Bush Sr. vetoed it because he didn't like the idea that employers had to justify who they hired and why they hired them. So, again, he vetoed it because it was going to be easier for employers just to hire minorities, and they didn't have to he didn't like the idea that they had to prove it. 1996 Prop 2000 or 209. This is California's bill that says that you can't take race into account, and it has stood thus far. You can't take race into account when admitting to schools, and it has not changed. And 2003, you can't use race as an advantage. A point system was okay, like it's in place now. Sandra Day O'Connor said that, but you can't use quotas. I think that's it, and that's all with the